Let's call this meeting to order of the Library Board. Roll call. Trustee Weimar.
Here.
Trustee Millen.
Oh, here.
Trustee Armstrong.
Here.
Trustee Savage.
Present.
Trustee Jenkins.
Yeah.
Trustee Fessler here. Also present are Director Deiters and our Board Secretary. And Trustee Hall is absent once again. Does anybody know where Kate is?
I think she's at Whole Foods. She likes that place a lot.
You know, she's getting close to being gone a year, and we're going to have to declare a vacancy. I'm getting a little tired of this, but we'll move forward at this point in time. As you know, we wanted to have a discussion this morning about the Prevailing Wage Act, recent changes and various interpretations of it. So we've invited our attorney from Kleinthorpe & Jenkins, Kathy Henn, here today to answer some questions. Actually, we've started a small project involving an irrigation system and landscaping on the south side of the building, and we're just really confused about what part of this project is covered by the Act.
Attorney Henn, could you begin with a basic explanation about the Act?
Sure, I would be happy to. In recent years, the Department of Labor has expanded the reach of the Act in many ways. It has imposed new notice requirements, and it has also toughened penalties for those who fail to comply with the Act. So it is something that's very important for you to know. If you look at their website there, and on the upper left-hand side, there is a place where you can click on prevailing wage. I think it just says prevailing wages, actually. And if you click on that, you can get actually the wages by month. So it's important to note here that it applies not only to construction projects such as a new addition, a remodeling, a new building, it also applies to maintenance of equipment within your building.
Listen, didn't we just file the prevailing wage ordinance? Isn't that enough?
We did file it, you are correct. In June, we would have had that done. But you have to understand that that's really a small part of compliance with the Act.
What about recent changes concerning the notice? You know, I heard the city attorney say at the council meeting something about language, you know. What do you mean?
Well, that is right, you're correct, and you must be paying attention because you're a very educated trustee if you're aware of the notice requirement.
Unlike some of our other trustees.
In Public Act 96-437, which became effective on January 1st of 2010, does require that we as a public body, provide public notice to those who are bidding on our projects, and we also provide notice to those who actually do the maintenance on our projects, that they must pay prevailing wage.
I've heard the references to certified payroll. And why should we be concerned with having certified payroll with the contractor? And how can we force them to do it? Sometimes they'll say they will do it, and how do I know they're really going to do it? And I'm responsible.
I know. I know it's a difficult position that public bodies are put in, and again, this goes along with the Department of Labor's position of really sort of focusing requirement for compliance with the Act, shifting it to public bodies so that contractors can't just pay whatever they're going to pay and the public body can say we didn't know about it. So the certified payroll requirement, the Act now requires that contractors submit certified payroll to the public body. That's supposed to show that they are actually making the prevailing wage payments. Again, there's a form that's available on the IDOL website for contractors to use. There is certain information that must be included, such as the worker's name, address, telephone number, social security number, their labor classification, hourly wages, number of hours worked, and then the starting and ending times of work each day. The certified payroll must be submitted no later than the 10th day of the calendar month for the preceding month. So for example, February certified payroll would be due by March 10th. Subcontractors who file false certified payroll, again, it's a Class A misdemeanor. For a Class A misdemeanor, you can serve up to 364 days in jail and a fine of up to $2,500. If a public body fails to comply with the Act, it is also a Class A misdemeanor. So again, 364 days in jail, up to a $2,500 fine. And then contractors and subcontractors who violate the Act can be barred from public contracts for a period of 4 years. So IDOL is supposed to maintain a list of what those contractors are. I've actually never seen that list, but my guess is it might be available on their website.
who's going to jail? Me or the director? Or can we send Trustee Hall since she's not here?
Well, as I said before, it is unlikely that any of you will go to jail because we haven't seen any situations where that has occurred in the past. But if the Department of Labor were to try to enforce the criminal consequences, it would certainly be the library director or other trustees that were involved in not the fact that prevailing wages were not paid. So let's get back then to the questions that you raised a few minutes ago about when prevailing wage must be paid and when certified payroll is required. And this relates to the actual landscaping project. And as your director stated before, he tried to combine all of these into one project to try to save money for the board. But unfortunately, that likely created some problems in this instance. If you just had a landscaping contractor who was doing general landscaping work, then certified payroll is not required unless it's part of a construction project. And again, this is an area where the Department of Labor has gone two different ways in what's required for a landscaping project. So we do expect that there will be some legislation in this area, so keep your eye out for that. If you had a tree remover contractor, so if you had separated that out and just had someone doing the tree removal, then certified payroll would be required and prevailing wage would be required for that. Same thing for your irrigation system contract. For tree trimming, that's treated more like general maintenance, and certified payroll and prevailing wage is not required as long as it is not part of a larger construction project.
Please, come quick! There's an emergency!
Let's go.
Oh, no, we should have called Kleinthorpe and Jenkins before we started this project.